at Tandon Co. Sir has over 17 years of experience and he's a member of Bar Council since 2003. He has experience in corporate transactions, mergers, amalgamations, acquisitions, foreign exchange, FDI, real estate, IPR, and whatnot. He has, under his leadership, his firm has been awarded as Gen Next under 40 Rising Star Award, recommended his firm as a benchmark litigation for the year 2020, 2019, 2018, and finalist as ALV 2019 awards. IDX Legal Awards in the year 2019, Best Firm Nomination in the year 2017 for Media and Entertainment, IT and Litigation by Legal Era. He has done his alma mater in ILS Pune. He has also obtained diploma in corporate laws from ILS. He is member of Delhi High Court, International Bar Association and Trademark Association. Well, I'd like to further introduce Kanika ma'am. Kanika ma'am is a senior associate at Tandon Co. She specializes in corporate finance, including mergers and acquisitions. She has gained specialization in restructuring, corporate management, and due diligence. She has, in her 6 years of work experience, worked for various conglomerates in e-commerce and real estate sector. Previously, she's also worked with 𝘂𝘪𝘧𝘧𝘦𝘊 for 2 years, and she's specialized in direct tax and advisory litigation. She's prepared schemes and she's obtained sanctions for those schemes from tribunals and particular courts. She's seasoned advocate in advising companies and multinational companies. She's done her LLB from campus of Center Delhi University 2014 in the year 2014, and she's a professional. She has professional membership at Delhi High Court and Bar Association. Thank you so much, and I'll let you guys take over the webinar now.
Thank you very much, Ruchika. It's been a pleasure to be here on a Saturday morning, and I hope all the participants are also eager enough to understand what mergers and amalgamation entails from a legal point of view. And thank you. Yeah, so let's begin. My endeavor in this session would be to talk about the M&As as we popularly know it as mergers and acquisitions. We will also try and give you a legal framework behind it from company law point of view, from taxation point of view, and from the point of view of Competition Act and FDI aspects. I'll be dealing with the Companies Act and Competition Act point of view, and my colleague Kanika will deal with taxation and other issues. So let's start. So, you know, when I came into this corporate practice, the first thing I looked for is a definition of merger, as to where is merger defined. And I realized to my surprise that merger is not defined anywhere. Yeah. Not even in the Companies Act or any other statute. You do find a definition of amalgamation in the taxation laws, but again, amalgamation is also a term which is not defined anywhere in the Act, Companies Act. So generally, what is merger or an amalgamation? Let me start with that. So let's say that you have company A and company B. So A plus B equal to C is really a form of a merger which translates itself into amalgamation. A going into B is a typical form of a merger and maybe not an amalgamation. So to put it in general terms, if two or more entities form another entity, it is an amalgamation. If one entity goes into another entity, then it is a form of a merger. Though amalgamation is really a subset of a merger itself. There can be many types of mergers. Actually, let me start with kinds of mergers and amalgamation, what we are going to deal with under these heads. So there is a concept of merger. There is a concept of acquisition. There is a concept of demerger, there is a concept of amalgamation, and there is a concept of joint venture. So these are the 5 heads under which the entire subject falls. each of these heads have a very thin line difference between them, because when we stand in court, actually when I stand in court, I always use it interchangeably. I can call one thing as a merger in court and that same very thing in the next sentence as amalgamation, and courts also understand that people use it interchangeably. But obviously, there is a connotation to each of these words, which I will try and explain to you as to what is the connotation. So, generally, the merging entity ceases to exist and stands merged into a single surviving entity. So, as I said, a company A merging into B, company A ceases to exist, and company B takes over everything that company A has and becomes company B. So as we say it, and as the provision in the Companies Act also says it, company A has been wound up without actually being wound up, because it has merged into B, existence has gone, and it has become company B. So what is the legal framework behind mergers? First, let's talk about mergers. What is the legal framework behind mergers? It is really a court-driven process. Under the old act, which was the Companies Act 1956, we used to have popular provisions called Section 391 to 394. The provision now we have is Section 230 to 232 of the Companies Act 2013. So really the steps are like this, that step one, get the client. Step two, prepare a scheme, and scheme really consists of all the provisions. It's really a contract between two companies, where two companies contract with each other as to how company A will be merged into company B. Scheme generally has provisions as to how the assets will be transferred, how the legal proceedings will be transferred, what kind of taxation effect will be given to the merger, what will be the appointed date of that merger. Now, this concept of appointed date is very important. The appointed date can be a date, is basically a date from which date you actually take over that company. For example, I can say that the appointed date of company A and company B's merger could be, let's say, 1st January 2014, which means that if my merger is accepted by the court, company A loses its existence retrospectively with effect from 1/1/2014. It is permissible. Everything since 2014, whatever company A has done, comes into company B. So it could be as retrospective as you can think of. Generally, it can't be more than 7 years, because then the taxation laws probably would bar you, because there is a 7-year provision under the act that the books and all are not there. So you can't go as back as like 15 years. Generally, we say don't go beyond 2, 3 years, 4 years. It could be the date of today. It could be the date of tomorrow. It could be the date when court accepts the merger. It could be the date that you want to accept a merger on 31st December 2020, or maybe 31st December 2021. So really that is really not something which is provided in the law as to what the appointed date could be. It could be anything. Then the next step, after you have drafted the scheme, the next step is to put that scheme before the shareholders of both company A and company B. Shareholders must accept and give their consent to that particular scheme. If it is a closely held company, generally we try and obtain a pre-first step approval from the shareholders, so that we can take an exemption from the court in respect of the meetings to be held. If it is a public listed company, obviously it is not possible for you to hold extraordinary general meeting prior to the scheme being approved by the court. So what the court does, as and when I explain how it happens, you'll know that court will either order for meeting of shareholders, or it will exempt meeting of shareholders. That's the first step in court. But before that, the shareholders must approve, the board of directors must approve, and then comes the court process, which is divided into two steps. First step is that you move the court. Under the old Companies Act, it used to be the Company Court attached to the Delhi High Court. And under the new Companies Act 2013, it is the National Company Law Tribunal of the jurisdiction where the company is registered. Assuming company A is registered in Delhi, assuming company B is registered in Bombay, then you will apply to the National Company Law Tribunal, and hereinafter I will refer it to as NCLT, of both Delhi and Maharashtra. So there are two NCLTs who will be involved here if the registered office of two companies is in different states. So first step, you go to the respective jurisdictional NCLT and apply to them and ask them for exemption of the meetings if you have already conducted meetings of the shareholders and secured creditors and unsecured creditors. 3/4 of the shareholders / unsecured creditors / shareholders must consent to the scheme. The court looks at that consent and says, okay, fine, you've obtained a consent and hence we grant you exemption. If that consent is not available, the court will say that you hold a meeting under the supervision of the court, and that meeting will be held, and that meeting there will be a chairman and a vice chairman who will be appointed by the court. That vice chairman, chairman will give the report to the court, and then the meeting is held. Minimum threshold is 3/4, which is 75%. Then after you have held the meetings or obtained an exemption, generally within 7 days of either the report being filed by the chairman or from the date of the exemption, you are required to file what is called as the second motion. Now again, these first step, first motion, second motion is not anywhere in the Companies Act. It is just a process developed by lawyers in court of first motion, second motion. So we go to the second motion. Second motion, we move the court for actually approval of the scheme. It is at this stage where the authorities like the registrar of companies, the official liquidator, the taxation authorities are issued notice to give their objections, if any. They all give their objections, and the court, after considering those objections, either approves the scheme or disapproves the scheme. And the court, when I say court, it is NCLT, also has the power to modify the scheme to suit the purposes of the objection, if at all. I haven't seen really any scheme getting disapproved because ultimately NCLT feels it is between the shareholders, unless of course 3/4 of the shareholders have not consented, or 3/4 of the secured creditors or 3/4 of the unsecured creditors have not consented to the scheme. At this stage also, any person from the public can also come and object to the scheme if the scheme affects public interest. So if that is the case, then somebody can even come and object. Generally, courts are reluctant in accepting those kind of objections. This brings me to the next important question. Companies Act 2013 brought in a substantial change. It brought in a concept of fast track merger. Now, what is fast track merger is? Wherever there are two or more small companies entering into some kind of a merger or amalgamation. Now, small companies are really where the capital of a company is less than 10 crores or the turnover of that company is less than 100 crores, then they can apply for this fast track merger. Fast track merger can also be applied to a holding and a subsidiary company, or it can be applied to such other class of companies which the central government may in its wisdom think that it must apply to it, so they can come out with a notification. application. So the procedure is really simple, that you go first to the registrar of companies and the official liquidator, present your scheme, get approvals from 90% of the shareholders, apply to the central government, which acts through the office of the regional director. And regional director, after obtaining no objection from the ROC and the OL, grants you this approval to the scheme. So fairly very simple procedure provided for that. So this is really what a merger in a typical sense would mean, and the legal process would involve. Now going to another form of merger is cross-border mergers. Assuming that there is a foreign company which wants to merge into itself a subsidiary company existing in India. Now that's also permissible. But again, the legal process remains the same under 230 and all those things. Sorry. Then, in addition to the process that I've already explained above, we can come to the procedure of listed companies. Now, listed companies, as you know, that there are shareholders who are public shareholders. So, in addition to all the approvals that you need in case of a closely held company, in case of a listed company, you need approvals additionally from SEBI, which is the Securities Exchange Board of India. You need approvals from the stock exchanges wherever the company is listed. It could be National Stock Exchange, Bombay Stock Exchange. There are cases of Ludhiana Stock Exchange even still existing. There are cases of Delhi Stock Exchange these days which are existing. So depending on which exchange the company is listed, you have to go and take a no objection from there. So that is an additional step which is needed, and so that basically is about mergers. Now this brings me to the second topic, which is acquisitions. Now, what is acquisition? Acquisition again is not something which is defined in any statute. Like in a case of merger, generally you are taking over everything that a company owns. For example, company A merges into company B. Everything that company A owns merges into company B. So the existence of company A is completely out, and company B takes over everything. Acquisition, on the other hand, could be acquisition of shares, in which case you become the shareholder of that company. Acquisition of assets, in which case you can take over the assets of that company. It could be acquisition of a particular asset of a company like a property. That can also be done. So it could be of various forms and means, in which it depends what kind of transaction you want to execute. And generally, acquisition, we don't suggest that we go to court or take the court route, because it becomes a very convoluted route for the clients. Hence, it could be a direct contractual route which is adopted. For example, if you are acquiring shares by way of a transfer of shares, assuming company A is held by promoter A and B, and company B is held by promoter C and D. So the shareholders of company A could sell the shares held in company A to the shareholders of company B, or to company B itself. So it could be 10%, it could be 100%. So ranging from anything to anything. So the steps really which are involved are, firstly, I think the company which is acquiring the shares of, let's say, company B acquiring the shares of company A, would firstly do the act called due diligence. Now, due diligence is of various kinds. First is legal, second is financial due diligence, third is technical due diligence, depending on what kind of activity is the company involved in. So once the due diligence report is given to the shareholders of the acquiring company can come and talk about the valuations of the company, and on that valuation you execute a document called share transfer agreement or share purchase agreement or a shareholders agreement or a combination of these two. So it depends on really the kind of transaction that you want to follow. Then there can be an acquisition of shares by subscription, in which case obviously new shareholders can subscribe to the fresh issue of shares in the acquiring company, and it could again be done in a lot of ways. So there are certain principles or regulations which you need to follow for that. One is that at what rate, at what valuation the subscription has to take place. So there are rules and regulations of SEBI in case of listed companies. There are rules and regulations under the Companies Act in case of unlisted public companies. There are rules and regulations in case of private limited companies. Of course, private limited companies are the least regulated companies, and you can really decide on the valuation as you may like. A chartered accountant certificate is required. In case of unlisted private public companies, again, the process is largely simple, where a fair market value can be determined by a chartered accountant who can give it to you. In case of listed company, these acquisitions become a little complicated, convoluted, because there is a regulation called SEBI Acquisition of Shares and Takeovers Regulation. So basically what happens is there are two thresholds. One threshold is that if you are acquiring a company for the first time, so the threshold is, I think it is now 25%. If you are acquiring anything more than 25%, then there are requirements under the takeover code where you have to give notice to the general public that we are going to acquire these shares at so and so rate on so and so date. If anyone has any objection, or if anyone has a better rate, can come and acquire it. I'm sure all the participants here must have seen notices coming out in Hindustan Times and Times of India. Generally, it comes on the third page because it's a very prominent action where the takeover code triggers. So it generally is on the third page, and these notices are given out to the public to come out with objections, etc. The second level where the takeover code triggers is which we call as the creeping acquisition. Assuming that we are already a shareholder in a company and we want to acquire further shares, and I'm all talking about listed companies. So if there is a creeping acquisition of more than 5%, so assuming I'm a shareholder, let's say up to 20%, I'm acquiring 6% more, then I call it as a creeping acquisition, and that 6% I have to follow the procedure provided in the takeover code. So this is really about listed companies acquisition of shares by subscription. Then we come to something called acquisition of assets or business. So you may not want to acquire the shares of the company. You may just want to acquire the assets of business of the company. So assets and business of the company can be acquired by way of transfer of assets by following certain provisions of the Companies Act. Generally, if it is a substantial asset of the company, then you need a special resolution to be passed by the company for sale of its asset or sale of its business. Another form which is very important is a demerger. Now, demerger is assuming, let me give you an example of a large entity. For example, let's take the example of Reliance Industries. You must be hearing in the news that Reliance Industry wanted to demerge its digital business. Now, what it really means is that Reliance Industry Limited till now owned everything for the purposes of better management, for the purposes of better taxation, for the purposes of better scenarios and better opportunities. They may have thought that it is best that two businesses, one petroleum and the other digital, in the same company are not giving us that much benefit. We must demerge. So what they do, that they will demerge a particular division of Reliance Industry, maybe digital division, and popularly they say that hive off. We will hive off this part into, let's say, Geo Industries. So company A, which owns 2 or 3 different divisions, may hive off its single division into company B by keeping the top shareholders same. So whoever are the shareholders in company A will continue to be shareholders in company B also. It can't be that they will hive off from company A and give it to someone else. That is transfer of business, transfer of assets. If they want to hive off into a different company, a division is hived off, then they have to keep the shareholders same. So that is one of the basic requirements of a demerger. The process, the legal process which is involved in a demerger is the same as in case of a merger. If there is a hiving off, then also at that stage also you need to follow the provisions of mergers which are there under 230 to 232 of the Companies Act 2013, which used to be 391, 394. Or if the demerger could also be created in a manner that it could fall under any kind of acquisition like shares or asset, then of course you don't need to go through it. So it would really depend on what kind of a transaction there is. But generally a demerger also goes through the court route.
Sorry to interrupt, sir. So is the scheme also the same, or is it the composite scheme of arrangement that you enter into at the time of demerger, or it's just like a regular scheme of merger that you enter into?
No, you can enter into any kind of scheme of merger. So like for example, we have done transactions which have involved merger and demerger at the same time.
Right.
So there can be a composite scheme for that purpose.
Okay.
But there can be a single scheme that you may not want to do everything together. You may want to first do your demerger in respect of a company, and then from some other companies just bring in business through a merger process. Okay. So there can be a composite scheme also. I mean, there's no bar under law that you can't have it.
Right.
Then the last form that comes to my mind is a joint venture. Now, joint venture, as the term suggests, is obviously when two or more people, I here obviously will be entities, join together to form a company. For example, Kanika and I have companies, Kanika Private Limited and Kunal Private Limited. Both of us say that, okay, fine, let's start Kunal Kanika Private Limited. So that's really a joint venture where we say that we have our own businesses in the name of Kunal Private Limited and Kanika Private Limited. But as far as a particular business is concerned, let's join hands and form another entity called Kunal Kanika Private Limited. That's really a joint venture where both persons remain shareholders in that joint venture entity and run that entity jointly, whereby we generally execute a document called shareholders agreement. Shareholders agreement generally specifies all the rights and responsibilities of each party, director, shareholder, how a meeting is to be held, how a board meeting is to be held, and ultimately all of that is incorporated into the articles of the company. So, so that is how really it is done. So joint venture, again, it could be of various forms. It could be where you form a distinct new company. It could be where you can work into a joint venture into an existing company. So it all depends as to what exactly the transaction is like. So now basically you've understood what is a merger, what is joint venture, demerger, acquisition. Amalgamation, as I said, is a form of a merger itself, where two companies come together to form another company. So that is really amalgamation, that you amalgamate two companies to form a company C. So A plus B is equal to C is the formula as we would apply there. The procedure is more or less the same. Of course, there are very thin line differences between what you call a merger or a joint venture or an amalgamation. The thin line difference being, let me give you an example. A plus B equal to C is a amalgamation, but it is a form of a merger. A going into B is a merger, but it is not amalgamation. A plus B forming C with shareholders of A and B is a form of acquisition or a joint venture. So that is really the difference between these three terms. But I must tell you, while I've been practicing in this field, every transaction poses a new problem for us, and we generally don't specify whether it is a merger, amalgamation, or whatever it is. But when we sit down and think, what would we call this as? It obviously poses a big question for us, because each transaction could be a merger, it could be a amalgamation. So it all depends on that particular transaction as to what really it is. So to really give you an example of what is the difference, yes, there is a difference, there is a thin line difference, but again, it would really depend on that particular transaction. Now, two aspects which I should deal before I hand over the discussion to Kanika. One is the Competition Act. I'm sure the participants here and all of you must have read about the Competition Act, where it said that if the effect of a particular amalgamation or a merger or an acquisition is more than a particular limit set by the government, I think it is set at 500 crores at the moment, or the horizontal agreement signed or vertical agreement signed between two entities causes an effect of competition in the market to the extent of 500 crores, then you are required in law under the Competition Act to obtain a permission or an approval from the Competition Tribunal, which is basically the Competition Commission of India. And that is a requirement of law you must follow. So the purpose is that two entities which come together do not become dominant, so dominant in the market that they start affecting the consumers. So they will generally like to study the effect of two big entities coming together and affecting the consumers. Assuming for a minute, if I say that assuming that Indian Oil and Bharat Petroleum is to merge, it will have a huge effect in the market, because one big entity is going out of the market and is merging into another entity, which means that the consumers will get affected adversely. There will be an adverse effect on the competition in India. Hence, the Competition Act with this purpose has been built up, that anything more than 500 crores must come to us before it goes to any other court. Hence, that is really the purpose. I'm not getting into the nitty-gritties of the Competition Act, how an application is filed, why an application is filed. All those things I think can always be looked at. But always keep one purpose in mind, two things. One, that it should not have an adverse effect on competition. And secondly, that there is a threshold limit provided which keeps changing. Right now it is, I think, 500 crores, but it can keep changing because the government notifies it. So these two things are met, you have to go to the Competition Commission of India seeking approval of your merger or an amalgamation, or even asset purchase agreement or any other kind of agreement which falls under those provisions. Now, last topic which I must deal with is the foreign direct investment. When we are talking of mergers and acquisitions, there could be sorry. When we are talking about mergers and acquisitions, there could be a scenario where the shareholders involved are non-resident Indians, or they could be non-residents, or they could be residents. In short, the difference between these three terms is non-resident is really a person who is not a citizen of India. Non-resident Indian, as the term suggests, is a person who does not live in India, could be an Indian citizen, who may not be an Indian citizen but holds an overseas citizen's card. So that is really a non-resident Indian. Resident, of course, I guess all of us are residents who live here for at least 182 days in a year. So that is the difference. So in effect, what is the requirement of the foreign direct investment laws? If there is a transfer by a non-resident transfer by a non-resident Indian to a non-resident, then no permission is required. Similarly, transfer by non-resident to a resident, no permission is required. Transfer by resident to a non-resident, no permission is required. However, there are sectors whereby certain permissions are necessary. Under the FDI, we have an automatic route and we have a permission route. Now, under the automatic route, you are entitled to come into India if you are a foreigner to the extent of 100% in a particular sector, set up an industry here, factory here. You do not need permission of the government, prior permission of the government, but you do need to report to the Reserve Bank of India as to what you're doing. Post facto reporting has to happen. In a government approved route, prior to setting up or bringing in money into India, you have to first seek government's approval. For example, in a defense sector is a government approved route. FDI for last innumerable years has been opened up completely, except I think there are really 4 or 5 sectors where there are restrictions now. And hence, I don't think that most of the sectors which we will be dealing with, or in common man's dealing, those sectors are going to be under the government route. Most sectors are under the non-government route of this thing. Again, I'm not getting into the aspects of transfer, because when you're transferring from a foreign citizen to a resident, permissions, etc., there are various nitty-gritties to be looked into from the valuation aspect. So I'm not getting into it, but valuation is one thing which is very important. It has to be done by a chartered accountant. It cannot be below the amount which you have invested earlier. So it always has to be higher. So all those things have to be kept in mind. So this really is about amalgamations and mergers. I now would ask Kanika to take over in respect of tax. And lastly, Kanika will also tell you about what all important clauses should be there in a scheme which is generally drafted for the purposes of merger and amalgamation. So first tax and then clauses of a good scheme that Kanika will deal with. Over to you, Kanika.
Thank you, sir. Thank you so much. Hi, everybody. So, okay, I'll probably want to simplify things as much as I can, because yes, we've already gone through a pretty heavy session and I don't want it to be too heavy on you now. So simply speaking, tax incidents, we all know, when does it arise? It arises whenever there is change of hands in respect of an asset, which we call as a capital asset. So what is a capital asset? Capital asset includes anything and everything. For example, it can be the shares of a company. It can be the immovable property of a company. It can also be the IPR of a company, that is your trademarks, which we call as intangible property. So whenever a capital asset is transferred, so the important word here is transfer, which is a well-defined term in the Income Tax Act, and it is so widely defined that it will probably include any and every kind of change of hands. For example, if there is a change of hands from A to B, that is simple by way of maybe sale or transfer by any other means, by exchange, but there can be another type which is very important in our discussion, is extinguishment of rights. For example, I have a property, I have a land today, and tomorrow I give up my rights, in that land, that I don't want it. For example, I co-owned the land with Kunal sir and 50-50 we were owners, and tomorrow I just relinquish my rights, that I don't want my 50%. Okay, so that is an extinguishment of my right. Even that is termed as a transfer, because that is giving up of something by somebody. So anything and everything, of course, even the judicial precedents have expanded the definition. So transfer is anything where there is a change of ownership. So whenever there is a transfer of capital asset, there is a tax incidence on that transaction, and that tax is called a capital gains tax. Of course, it's called gains, capital gains, but it can also be like a loss for somebody in some situation. So what is a capital gain? Simply just say, everybody must be knowing how to compute a simple profit. How do you compute a profit? That is your purchase consideration and minus the cost at which you bought that thing, which is called the cost of acquisition for you. So capital gain similarly is the consideration that you receive upon a particular transaction. Of course, there can be money involved, there can be non-cash consideration, but yes, the value that you receive, and then you subtract from it the cost of acquisition, which is the price at which you bought the particular thing. Now, there may be a situation that I bought a particular land in 2010, and after that I made substantial improvements to that land. Just the way we build a house, we buy a land for say 10 lakh rupees, we spend another 5 lakhs for permissions and sanctions, and then we spend another 20 lakhs for the construction of 5 stories above it. So I'm spending all this money that keeps adding to my cost of acquisition. So essentially we sum up all this and then we subtract it from the purchase consideration, and the differential amount is the capital gains in our hand. Now, who is liable to pay this? Of course, the person who gets the money. The Income Tax Act obviously seeks to tax somebody who receives money. Anybody who gains benefit has to pay out of it. So that's a capital gains tax, and we know now the formula, how to come at. Now, capital gains tax is further divided into 2 subcategories, which is a short-term capital gain and a long-term capital gain. Short-term and long-term are mainly differentiated by the period of holding. So for example, as I said, if I was holding a piece of land for 10 years before I sold it, that is a long-term capital gain. However, if I bought it, say, a year back and then I sold it today, it's a short-term. So for different types of capital assets, different holding periods have been prescribed. 3 years or 12 months or 24 months, depending on what kind of asset it is. So it will be either short-term or long-term. Now, why this is important is the rate of tax applicable. So I know ki, if I make 100 rupees in a transaction, 100 rupees is my profit, which is my capital gain. Then my rate of taxes, for example, in a long-term capital gain, it can be 30% of that 100 rupees. As against this, a short-term capital gain is always a higher rate of tax. I mean, it is different. The slab rates are different for different assets and transactions. But of course, it's usually a higher rate of rate of tax. It can be maybe 40% or the applicable slab rate. It's very there's too many of them, so it's better that we see it transaction by transaction, and plus the rates also keep changing with every finance bill. So yes, we have to be updated with that, and there cannot be a straitjacket table that I can give you today. All right, so now we know the kind of tax we are eligible to pay. Of course, whenever we are doing any transaction, merger, acquisition, amalgamation, merger, what is the motive? Whatever be your motive, your first and foremost motive has to be to make profit out of it. How do you make profit? One is if you get good money out of it. Second way is, a penny saved is a penny earned kind of a scenario, where if you save the tax outgo, then you obviously are making that much money for yourself, so you're maximizing your profit. So in any transaction, obviously a businessman will look at maximizing their profit by minimizing the tax incidence. We as legal advisors have to now tell them that, boss, this is the transaction you're doing. If you follow these steps, we can get you an exemption under the Income Tax Act. So now the Income Tax Act gives you a lot of situations where this capital gains tax is exempt on a particular transaction. There is a big list. I will possibly, take you through 3 or 4, particular exemptions in the light of what Kunal sir has just discussed, the kind of transactions. So for example, in an amalgamation, when there is a transfer of a capital asset, from amalgamating company to an amalgamated company, that they say is exempt from tax if the amalgamated company, which is your C company, A plus B is equal to C, the C company, if that's an Indian company, then they say that this transfer of capital asset is exempt from tax. That is first example. Then second example, for instance, if there is a foreign holding company and that transfers, it has some shares in an Indian company, company A incorporated in USA has shares in company B, private limited in India. So in an amalgamation transaction, Kunal sir also discussed that the shareholders of company A and B have to be shareholders of company C. So there is a certain transfer of shareholding. So as a result of amalgamation, when a foreign holding company transfers its shares of an Indian company, then this transfer is also exempt from tax if 2 conditions are met. That is, at least 25% shareholders of the amalgamating companies. Matlab jo company A and B ke, if there are X, Y, Z and maybe P, there are 4 shareholders. If 25%, that is even 1% of this becomes the shareholder of the amalgamated company, and the second condition is that this foreign company which is transferring the shares, for example, it's in US and capital gains tax on this transaction is exempt in US. So if these 2 conditions are met, then India also will not levy a capital gains tax on this transaction. So that's another example. Now, for example, a third thing is in a demerger. In a demerger transaction, how do you make a tax neutral demerger? Tax neutral demerger can be made if all the properties, so as Kunal sir said that, in a demerger, you are hiving off a particular business segment. So, okay. So now, if in that business segment, you actually hive off all the properties, assets and liabilities, of that particular undertaking, we call it an undertaking. It's a very judicially defined term. An undertaking is essentially a bucket which has your assets, your business, your employees, your liabilities. So something that can stand on its own feet as a business is an undertaking, okay? So when all the assets and liabilities and properties of an undertaking are transferred to the resulting company, the demerged entity, जिसमें आप लेके गए हो अपना hived off business, and these properties and liabilities must be transferred at a fair value. There is a prescribed method that, under the Indian accounting standards, you must have all possibly heard that there is something called accounting standards. If you follow that method, when you are, giving value to each property and asset and, and liability that is being transferred, next condition is that the resulting company issues its shares to shareholders of the demerged company. So, see, essentially, I'll tell you, the tax laws will give you exemption, just like Kunal sir said, that if the shareholders remain the same, then the transaction is treated as exempt, because legally, and actually, practically speaking, there is no change of hands. Who is the owner of a company? A shareholder, essentially, right? So if the owners are the same, the heads of both the companies are same, then essentially they see it as a mere restructuring, that money is remaining in the same hand as I started. It should change hands for there to be a tax incident. So mostly in the exemptions that are listed down in Income Tax Act speculate that if the resulting entity also has the same set of shareholders more or less, then the transaction is taken to be exempt from tax. Of course, whenever you come across any other kind of transaction, you go to these particular, these are listed in section 47 of the Income Tax 1, 2, 3, 4. You can just find out that if my particular transaction falls in any of those, then you're home. So this is our role as a legal advisor, that we tell them that you are doing this, so but you must issue the shares to those shareholders, warna aapko tax lag jayega. And anybody will want to modify it a little bit if they're saving tax, right? Now, coming to a very important aspect in Income Tax Act, whenever you're advising anybody on a transaction, I see that some of the people have talked about, how is a consideration calculated and etc. In tax, fair market value is a very important concept. Whenever there is a transaction, the value at which the transaction takes place, matlab jo sale value hai kisi cheez ka, that must be at the fair market value. Now there is a very long formula in Income Tax Rules 11 UA, UB, UC. There is a long formula as to how do you compute this fair market value. A transaction must undertake at the fair market value. Why? There are two, this is like a two-edged sword. So if it's not at fair market value, so for example, if it has a value, if it is at a value lower than the calculated fair market value, then the differential, which is like the fair market value itself. For example, fair market value when we computed was 100 rupees, but you do the transaction at 80 rupees. So, when you compute your capital gains, you will say that I only got 80 rupees, so I'll do 80 minus 70, 10 rupees capital gain. No. Income Tax Act will say 100 rupees, which is the fair market value, is your cost of consideration. So you will do 100 minus 70 and then you pay tax on 30. Even though you got 80 rupees, but a notional value is fixed at the fair market value for the purpose of computation of the capital gain. So that's the downside agar aap fair market value se niche kar rahe ho. Now if you're doing it at a value higher than the fair market value, for example, a thing is valued at 100 rupees, but I paid 200 rupees for that thing. So now the difference between 200 and 100 is taxed in the hands of the purchaser. This is a very new thing. Usually we always see that, the seller always pays tax kyunki he gets the money. But this is like a notional income tax in the hands of the purchaser, that why did you pay extra money? You have too much money. Okay, now you pay tax on it, kind of a thing, So if the thing was at 200, but you paid 200, so 100 rupees is taxable in the hands of the purchaser under the particular provision, 56.
Usually in the properties, like if you purchase any real estate properties, it happens.
Correct. Exactly. Property also, even shares also, anything. But yes, usually we notice it in the case of property.
Properties, yeah.
Correct. Perfect. So now another type of transaction which Kunal sir talked about was a slump sale. Slump sale is something like pura business, a whole undertaking you are selling. Now, in an undertaking, there are 10 things. There is 2 lands, there is 3 factories, there is 4 employees, all these things. So there are 2 ways to go about it. One is that the consideration that you affix is to the specific assets, that, in this whole 10 things, 100 rupees land, 200 rupees factory, 300 rupees employees, and then you add it and you make a consideration. So you're ascribing separate value to each asset. Okay. But when you don't do this and you give it like a package, that this packaging business that I'm buying is not more than 500 rupees, you don't give a specific value. It's like at a lump sum value. So slump se aap samajh sakte ho, lump sum. Okay. So whenever the transaction takes place at a lump sum value without fixing any specific values to any asset, then that is a slump sale. Now, slump sale transaction mein how do you compute capital gain? The formula remains the same, consideration minus acquisition cost. Now, in this case, slump sale mein cost of acquisition, what is cost of acquisition in a slump sale is the net worth of that undertaking. Now, there is a formula for net worth also, okay, which is simple, total assets minus total liabilities is net worth. So, now how to save tax on a slump sale transaction? If you sell the undertaking at the net worth itself, so your net plus and minus is the same. So net worth minus net worth, that will be a zero tax incidence. That's a very powerful tool. A lot of advisors tell their client that, you know, you make the transaction, you calculate the net worth and you buy it at that particular net worth so that your resultant tax implication is zero. Okay. Now, so this is about the different types of transactions. Of course, there is a whole lot to it, you know, because the transactions ka permutation just keeps changing. So you have to find out where you fall and how you can apply the law to your benefit. Another quick important thing is whenever there is a foreign entity involved in a particular transaction, for example, company A plus B ho raha hai, you know, company A is selling something to company B. A is in India, but B is in, say, US. Now you must know that India has entered into bilateral treaties. We call it a double taxation avoidance agreement, that is your DTAA, with almost all the countries. That is available on the income tax website, the treaty that India has entered. So suppose, you know, in a transaction, as per the Income Tax Act, aapko 30 rupees tax lag raha hai. Now you will quickly go to the treaty. The treaty also has definitions and formula of, you know, how much tax will be there on a particular transaction. So if you see that under the treaty, you are getting a lesser rate of tax, you can take the benefit under the treaty. So whenever a foreign party is involved, you must see the treaty and find out if you can save some tax from the beneficial provision contained in a particular treaty also. Then when we talk about foreign players and transactions, another important aspect is transfer pricing. I will not discuss it too much. Again, you will find a whole lot of precedents and it's ever evolving subject. Transfer pricing is whenever there is a transaction between associated enterprises, which is like, you know, associate companies, group companies, holding subsidiary companies, related companies.
Yeah.
So you have to comply with the transfer pricing provisions, and the pricing of such a transaction must be at arm's length. Now there are formally and, you know, the way to compliances that you can see, but yes, do not ignore this aspect whenever you are advising a particular client. Then the last thing is where will a taxation take place, you know, when there are different players involved, you know, a foreign player and an Indian player. So a simple 2 rules I'll tell you. For a resident, any income that you earn globally, even if, you know, Kanika lives in India but has a business in Dubai and US, so whatever my Dubai and US businesses make now, I'll have to pay tax on it in India itself. Okay, so a resident, the global income is taxable in India. For a non-resident, any income that they make from the transfer of a particular asset in India or because of assets situated in India is only taxable in India. Of course, you can't tell a US citizen to come and pay tax in India, but they have to pay tax in India only to that extent that that income is arisen from transfer of assets in India. So that is the rule of taxation, the 𝘖tos of taxation as we call it. So this is broadly, extremely broadly, the taxation implications and minimizing tactics that we must figure out when advising in a transaction. Without wasting too much time, I'll quickly move. Actually, Kunal sir has covered mostly the heads that are in a scheme of merger, but I'll quickly just tell you what are the different heads customarily. Of course, you are free to build upon it, but yes, there are certain essentials which are preserved. Now, as he said that the scheme is essentially like an agreement between the two companies that, okay, we are merging. So, you know, from this date, all your accounts and liabilities and assets, which is the appointed date, will be mine. Then after merger, we'll be called this, and this is how our business will be, and so on and so forth. Now, the important thing to cover in a scheme is essentially who will bear. So there are 2 dates. One is an appointed date, one is an effective date. Appointed date is the date which is the cutoff date, that from this date all your, when I say me and you is the merging company which is going to lose its existence, which is getting absorbed in the merged company. Okay, so it is mostly from the angle of, you know, saying that suppose 2017 we take as the appointed date, 2017 onwards all the liabilities, assets, litigation of the merging company go to the merged company. But what is the effective date? Effective date is the date on which you actually receive all the approvals and consents from the NCLT or any other authority that you need, and when your merger is final. Okay, that's the effective date. Now, when Kunal sir said that it can be retrospective, so of course you see that agar 2017 is your appointed date and you got all the approvals in 2020, there are 3 years of gap. You know, in these 3 years, merged company Now they have to now decide that what will happen in these 3 years, whether the merged company will take over the liabilities or assets, or who will take over. So for example, there is a tax incidence, who will pay it? So things like this. And second, you have to say in as many words that what all things are getting transferred, your contracts, your employees, because this will be important for your statutory authorities. When they see a scheme, they will want to see that the scheme is not made merely to defeat some statutory dues. For example, employees hain aapke paas, you have PF dues towards your employees, or gratuity dues which are payable after 5 years. But then in the scheme you make a clause that all the employees will be terminated. So the authority can say that you've made this scheme only to defeat the claims of the employees. So these are the things which we must keep in angle. So now I'll go quickly by the heads. First, you have the preamble, which has all the details of the company, name, address, identity number, so on and so forth. Then you have the rationale. Why are we doing this scheme? What do we want to achieve? That, by this merger, we are looking at synchronizing our powers and, customer base. So you give the objective that you desire to achieve. Then you come to the definitions, which is a simple, in any other agreement, you will see definitions. Taki, a term which is recurrently used in the scheme, you define it at one place, so you don't have to keep detailing it everywhere else. Then you have the details of the share holding pattern, pre and post. First of all, so and so is the share capital of A company, share capital of B company. After the merger, shareholders of B company will get shares of A company, and so on and so forth. Under this, an important thing is the share exchange ratio. So you see that the shares are getting exchanged. So this company is giving shares to this company, and this company ke shares are coming to the shareholders of this company. So there is a lot of share exchange. So this ratio has to come out by a certified chartered accountant. There is a certificate that you need to come up with. Then you give details of all your contracts and agreements, specifically for the merging company, because merging company to khatam ho jayegi after the merger, it will cease to exist. So what will happen of its liabilities and responsibilities under the agreements? You have to spell out that merged company will be taking it over or not. Then you will say about the accounting treatment. So different methods of accounting are prescribed under the Indian laws. Then you will decide that after merger, company A का XYZ method था, उसका PQR method था. After the merger, we'll follow this particular method. So you have to tell those things. Then you'll talk about taxes, as I said, that after the appointed date, if any tax incidence arises, who will take responsibility of that? Then you will say, so again, a scheme is a scheme which is commonly made in a merger transaction, in a demerger transaction, a merger of a different type, in an amalgamation. So you'll have to tell them, say this in the scheme that, this is to be treated as an amalgamation in terms of section 2(1)(b) of the Income Tax Act, so that you can avail the relevant exemptions easily. Then you will talk about the legal proceedings ka status. If the merging company is party to legal proceedings and it will cease to exist after the merger is over, then what will happen about the legal proceedings? Who will step in the shoes of the merging company? Whether they are settling litigation, what is going to be the status? Then labor issues, whether the labor will be transferred, not transferred, at what terms will they be transferred, so on and so forth. Then you can possibly discuss the methodology of approaching the tribunal, of how do you think that you will get the consents? Will you conduct meetings of the shareholders, or you will take as a first step you will take their consents and seek dispensations? The methodology of approving this. Then you can obviously, as a general contract, talk about who will bear the expenses of this whole merger, your lawyer fees, your court fees. A lot of expenses are entailed, that who will be liable, and then you can also possibly talk about what happens if the approval doesn't come. So after the aaj aapne scheme banai, you took the appointed date as 2017. So now all the liabilities are taken by the merged company. ठीक है, अब 1 साल तक merger process is going on and on and on. But after 1 year, you see that the consent did not come. My merger failed. Then what happens? In this 1 year, all the things that were done have to be undone. So you basically discuss as to who bears the fallout. So these are broadly the heads. Now you must understand the essence is to basically define the roles and responsibilities and liabilities of respective parties. It's as simple as that. Of course, you can build it up with your own wit and humor. So, yeah, I think that would be what I had to say about these things. Unless, of course, there is something I must fill in if you think I've missed something.
Thank you, Kanika, and thank you, Kunal sir, for enlightening us, sparing your time on Saturday morning and doing this for us. Thank you so much. It was really informative. Well, there's one question from Shiva, if you would like to answer. It's about taxation. He says if a private limited in A private limited intends to demerge one of its business segments into B private limited. Say there are 10 shareholders in A company, but the shareholding majority of shares in A company, say shareholder number 1 and 2, only want to become shareholders in B company. Can this transaction be legally done without any tax consequences?
No, again, so as I said that you have to meet the basic threshold of falling in the demerger tax exemption that is provided. So in this case, out of 10, what will be 3/4? So for example, about 7 people to the least will have to become the shareholders of company B for it to be qualifying as a tax exempt transaction. Oh, sorry, in this case, you are saying only 2 don't want to become or want to become. Hello? Ruchika, are you here? Okay, so I'll just finish my answer here. So yes, for it to qualify as a tax exempt transaction, apart from other conditions, as far as shareholders are concerned, at least 3/4 of shareholders of A have to become shareholders of B. Hope it is answered for you, Shiva.
I think we've lost Ruchika.
Yeah.
She's not connected. Can you hear me?
I can hear you. I think we've lost Ruchika only.
Okay, till the time she comes, I think there is a question by Ms. D'Souza.
Yeah. Right. So first question she has is, will the procedure for a merger amalgamation differ from the general manner if initiated through an IRP by the recommendation of the RP?
So the process more or less remains the same. What happens is that in case you want to exercise your right under section 230, that applies to a liquidation proceeding under IBC as well. So process remains the same.
Of course, in this case, a scheme can possibly be taken place by the resolution plan, sir, if I'm not wrong. You know, the resolution plan essentially accommodates all the details that are usually required in a scheme, of course, with some modifications.
No, I think we need to detail it for them. You see, in a scheme, what happens is that the company is not under insolvency. If the company is under insolvency, there are again in the Insolvency Act, the code, there are 2 steps involved. One is the corporate insolvency resolution process. In the corporate insolvency resolution process, the COC, which is the committee of the creditors, along with the resolution professional, decides as to what kind of resolution plan should be there for the company. If the resolution plan comes, then of course the process is not there. The process of merger is not applicable at the CIRP level. Assuming that there is no resolution plan at the CIRP level, which is the corporate insolvency resolution process, generally after 180 days to the maximum of 330 days from the date of the admission, the company goes into liquidation. Once the company goes into liquidation, at that stage, if someone wants to float a scheme for takeover or acquisition of that company under liquidation, then section 230 can be applied of the Companies Act. Then the process is the same.
Right. Now there is just another question that I'm seeing here, sir. In the scenario of a demerger of a publicly listed company, how is the consideration calculated? And second part is, can a shareholder raise an objection to the same, in what manner?
You want to take that?
Yeah. So, okay, as we've discussed that even a demerger is a code-driven process similarly. So you see that sir discussed that in this process, there are two steps. In fact, so in the first application that you make to the NCLT, either you seek consent from all the creditors and shareholders. So by conducting of a meeting. So who are the shareholders in a publicly listed company are maybe 100 odd people. So in a publicly listed company also, the first opportunity for them to raise an objection is in that meeting that is being conducted in the first stage. Now when we go to the second stage, after the meeting is done and then we go to the second stage before the court, even at that stage, the scheme is published in a newspaper. After that, the invitation of objections is invited from the public at large, which can include their shareholders or anybody from the public at large. They can now come and present their objections before the court. So there are two stages in which the objections are dealt with in a demerger. And as far as the consideration is concerned, of course, we just talked about the different aspects of, maybe if there is FDI involved, then there is a different pricing methodology there. From an income tax perspective, fair market value methodology is different. So yes, you have to comply with all these applicable laws and come down to a consideration, which is, of course, a corporate decision taken by the management of different companies. Hope I was clear about this. Ruchika, is there any more questions or?
No, Kanika, I don't think there are any further questions. And you've very comprehensively answered all of them. Thank you so much, Kunal sir and Kanika ma'am, for sparing your time and doing this webinar. It was really helpful. And I'm looking forward to do more of these if you have the bandwidth too.
It's been a pleasure, and we've had a lovely, attentive audience given all the questions. So yes, thank you guys.
Thank you, Kunal sir. Thank you, ma'am.
Thank you very much.
All right. Good day, everybody.